Um, so good afternoon and welcome to this Talking Difference session. In a moment I'll introduce our speakers, but first of all a few housekeeping notes. So we're due to last until 1:30 and we'll have a break halfway through, but if you need to leave before that or take a break, then please do so, and just remember to mute yourself. I will mute everyone anyway, I think, when the speakers are talking, just to keep the background noise down. Now I need to turn my live captions on in a second. Please take a moment if anybody does want to access the BSL interpreter to pin the interpreter to your screen. It will be Lisa interpreting first and then Christy. We are recording this session so that other people who can't make it now will be able to view it afterwards. We will have copies of the slides that we can distribute to everybody afterwards. So don't feel you need to make lots of notes. After each speaker, we will have a chance for questions. So if you raise your hand at that point, we will we'll take questions then. Right, before we start on today's session, I'm just going to enable the transcription, which I forgot to do. Okay, so that's on now. If you want to access that, I think it's a CC button on the screen. Okay, so today's session is about disability discrimination at work, and I think many of us disabled people will have experienced issues at some point or other, either in work or when looking for work. And so we thought it was useful to get a refresher on what protections are available to us as disabled people when it comes to discrimination at work. So we have two employment law specialists to talk to us. I'm going to invite Claire Rennie from Eversheds Sutherland to start us off with an update on the law and case law to give us a good grounding in how the law protects us. Claire, can I hand over to you?
Thank you, Richard. I will just share my screen. So can everybody see those slides? Okay. Yeah. Okay. My name's Claire Rennie. I'm an associate solicitor with Eversheds Sutherland. My part today really is to give an overview of the law that is applicable to discrimination. As a firm, we do represent respondents and businesses. Therefore, when it comes to questions at the end, I will be unable to comment on specific circumstances, but I am more than happy to answer any questions on anything that I have given you in the overview that may not be clear. So if we move on, so disability discrimination is covered by the Equality Act 2010. Now, the Equality Act came into force on the 1st of October 2010 and replaced a number of other legislation within the British legal system. It's concerned with discrimination and harassment in respect of protected characteristics, and these include age, disability, gender reassignment, marriage and civil partnership, race, pregnancy and maternity, religion or belief, sex or sexual orientation. Obviously, the one we're concerned about today and is most relevant to you all is the disability aspect. Now, under the Equality Act, the definition of disability is a person has a disability if they have a physical or mental impairment and the impairment has a substantial and long-term effect on that person's ability to carry out normal day-to-day activities. Now, in terms of what is meant by day-to-day activities, it's things like shopping, going out the house, washing your hair, things that people take for granted and are able to do without thinking about it. Now, the substantial and long-term effect, so that disability has to be in place for 12 months or more. So we're not talking about somebody who has been off work through stress for 3 months because they broke up with a partner or because they had a bereavement. That's a life event. That's not a disability. Okay. So who is protected under the Equality Act for disability discrimination? There's a wide range of individuals that are protected from harassment and victimization, as well as disability discrimination. It protects both job applicants, those in employment, and in that it's under a contract of employment, a contract of apprenticeship, or a contract personally to do work. So it's a wide range of people that are protected. There's 6 types of discrimination: direct discrimination, discrimination arising from a disability, indirect discrimination, failure to comply with a duty to make reasonable adjustments, harassment and victimization. Now, in terms of direct disability discrimination, discrimination arising from disability or failure to make reasonable adjustments, an employer cannot be liable for those 3 things unless it knew or should have known about an employer's disability. So you can't say, well, it's obvious that I suffered from this disability. It's obvious the employer should have known that I suffered from this disability. There has to be knowledge. If somebody can prove that an employer has knowledge of that disability, then that's the first hurdle. A particular difficulty for employers in terms of disabilities is the so-called invisible disabilities. and they may only impact somebody or become evident in particular situations or in relation to certain duties or responsibilities. So examples of so-called hidden or invisible disabilities, things like autism, dyslexia, PTSD, diabetes. There's obviously two diabetes. There's type 1, type 2. Sometimes it's obvious if somebody's having to take the insulin, but sometimes diabetes is managed by diet, which perhaps isn't as obvious. And I think what's particularly relevant in the current climate, in the current circumstances, is mental health difficulties, depression, anxiety, stress. Those are particularly difficult for employers to have knowledge of. So turning to direct discrimination, I will go through each type of discrimination and give an overview just to help people. So direct discrimination occurs where, because of a protected characteristic, A treats B less favourably than A would treat others. And that is because of their disability rather than on the grounds of. Okay. So that would be if a person is treated a certain way because of something they cannot do because of their disability. Yeah. It does not mean that the discrimination occurred because of, or one occasion could be that the discrimination has not occurred because B is disabled. It could be because of B's association with someone who has a protected characteristic. So, for example, if you have a parent who has a disabled child who has to take additional time off work to care for that child, to take to hospital appointments or other medical appointments, and they are treated less favourably by their employer because of that time off, then that would be direct discrimination because they are having to take that time off as a result of their child having the disability. Yeah. To be successful in a claim for direct discrimination, that person who is claiming direct discrimination must show they have been treated less favourably than a real or hypothetical comparator. So that is, they must show that a person who shares their relevant circumstances. So going back to my previous example, if there was two parents, both with young children, one with a disabled child, one without, both having the same time off work, but the person with the disabled child was treated less favourably than the person who didn't have the disabled child, they would be able to demonstrate direct discrimination. It wouldn't be the same if both parents had a disabled child and both were treated less favourably, because they would have been treated the same way by the employer, but then they would have still cause to bring claim for discrimination. Okay. The next one is discrimination arising from a disability. So this occurs where both A treats B unfavorably because of something arising in consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim. So, for example, if there is an employee who is visually impaired, and that as a result of his impairment, they cannot work as quickly as their colleagues, and he is dismissed because of his low output, that dismissal will be discrimination arising from the disability, unless his employer can show it is objectively justified. Now, in terms of objectively justification, that's up for the employer has to say, well, they couldn't work as fast as a consequence of their low output. For example, we would have to hire somebody else to keep up with the work. That's an additional cost to the business. Whereas small business, we can't have that additional cost. That may be something that could be objectively justified. To be successful in a claim for discrimination arising from disability, the tribunal must identify whether that person has been treated unfavorably and by whom. So that person who's bringing the claim has to say what the unfavorable treatment was and who made the unfavorable treatment. The tribunal then has to determine what caused the treatment. So what was in the mind of the alleged discriminator? What was in the thought process of that person who made the decision to dismiss? Did they dismiss because of the disability? Did they dismiss for another reason? The knowledge to be successful in a claim is that the employer has to have knowledge of the disability. They don't have to show knowledge that there's something leading to the unfavorable treatment was a consequence of the disability. So in my previous example, the employer wouldn't have to be proved that the employer had knowledge that that person could not have the output as quick because of their disability. They would just need to know they had a disability. An example of this is I'm currently working on a matter where the claimant was relying on a diagnosis of autism to prove discrimination arising from disability. Now, that person doesn't have a diagnosis of autism. It is just something that they think they suffer from. They've looked on the website, believe they checked a number of boxes, and believe they have autism. Obviously, that aspect of the claim can't proceed, because how can an employer have knowledge of something that the person bringing the claim doesn't have knowledge of either? Okay. Sorry, my mouse stopped working for a moment there. Moving on to indirect discrimination. So this concerns acts decisions or policies which aren't intended to treat anyone less favourably, but which in practice have the effect of disadvantaging a group of people with particular characteristics. So, unlike discrimination arising from disability or direct discrimination, there's nothing to suggest that an employer needs to know, so we don't need knowledge of an employee's disability to indirectly discriminate. The disadvantage experienced by a person has to flow from the provision, criterion, or practice that is being applied to them. Now, a good example of this, which many people are familiar with, is sickness policies and sickness triggers. Clearly, somebody who has a disability is more likely to have more time off than somebody who doesn't have a disability, which means they're more susceptible to hitting a trigger point in a sickness absence procedure. What you normally find is that is one of the adjustments that a company will make for their PCP. So they're not applying it across the board, they are trying to make that as an adjustment. The next one, which I think everybody is familiar with, is a company's duty to make a reasonable adjustment to premises or working practices to help disabled job applicants and employees. A failure to do so is a form of discrimination. So again, going back to my previous example, an adjustment to a sickness policy is a reasonable adjustment. If somebody, for example, is suffering from extreme anxiety and a company brings in hot desking, that the effect of bringing in the hot desking is going to have more of a detrimental effect on somebody who is already suffering from anxiety, and a reasonable adjustment there may mean that they get a fixed desk rather than having to hot desk. When looking at reasonable adjustments, there has to be a consideration of the size and the resource of a business as to what is reasonable. Clearly, asking a small business to make adjustments that could cost thousands of pounds is different to asking a larger business who've got a lot of resources to make the same adjustment. So it's not a case of, one size fits all. It is very much, you have to look at the circumstances of the adjustment, the circumstances of the business, the effect it would have on that business, as well as the individual, if the adjustment was made or if it wasn't made. Okay. Harassment. Now, one of the protections under the disability discrimination is from harassment and victimization. So disability harassment occurs where A engages in unwanted conduct related to disability, and that conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. Now, in deciding whether conduct has that effect, the tribunal must take into account B's perception, the other circumstances of the case, and whether it is reasonable for the conduct to have that effect. Now, one of the things is, again, if we go back to somebody who is suffering from anxiety, who is an extremely anxious person, a comment is going to have a different effect on them than it is to somebody who isn't already suffering from anxiety or anxiousness. And that's what you're looking at. Is it reasonable to somebody suffering from that same ailment for them to react in that way? So conduct related to disability covers, for example, a person shunning a co-worker because they use a wheelchair. So it doesn't have to be employer, employee. It could be two employees. The employer has to take reasonable steps to ensure that that behaviour is addressed in the workplace. The conduct, regardless of the reason for it, it is the form it takes. So it could be telling jokes about disability. Sorry, I have a flying cat. So it could be jokes about a disability that aren't directed at anyone in particular, but other colleagues may find offensive. It could be that somebody who hears that joke has somebody related to them or a friend who is disabled, and they will find that particularly offensive to somebody who doesn't. Harassment usually relates to a person's, the victim's disability or perceived disability, like direct discrimination. But the tribunal have to look at the full circumstances of the case, what action has been taken, whether a person has been warned of their behaviour before in relation to the jokes they're telling. And this comes across in employers often have equality and diversity training, and that will be looked at closely. Victimization. Now, this is different to harassment in that this occurs where a person A subjects B to a detriment because B has done, intends to do, or is suspected of doing, or intending to do a protected act. Now, protected act is bringing proceedings under the Equality Act, giving evidence or information in connection with proceedings under the Equality Act, regardless of who brought those proceedings, doing anything for the purpose of or in connection with the Equality Act, or alleging that the discriminator or any person has contravened. So, for example, if you have somebody who has complained to management that they find that they feel that harassment is occurring because of jokes being told in the workplace and no actions being taken, that they're finding offensive. I've got a case at the moment where there was a person in a business who brought a claim for disability discrimination against the employer. That claim was settled and they moved on to a different company. Unfortunately, people from his old company knew people from his new company, made certain noises that this person was a troublemaker, and as a result, that person was dismissed from their new company. Now, that is victimization. They don't have to work for that company, and there's no time limit on when a person can bring a victimization claim. That person lost their job because his old company said they were a troublemaker, and that was down to him bringing proceedings in the employment tribunal. So that was the protected act, and that's extremely difficult for anybody to defend that. I have got some recent case law, but is there any questions you want to ask me on any of that in the meantime? I know it's very much a whistle-stop tour of the Equality Act.
Hearing you talking, which is really great, by the way, it strikes me there's a lot of wriggle room for, you know, employers to say, you know, you didn't know, or you know, it's beyond our means, or the reason. Do you know what I mean? It seems there's a lot of wiggle room.
It might seem that way, but actually, you know, that it is a very high threshold that employers have to cross and have to meet, because, you know, it's very difficult. For example, a local authority going to court to say, oh, we couldn't possibly move this person jobs because we just don't have the resources. Any tribunal is going to say, come on, you employ hundreds of people. I'm sure you could make this person part-time.
Right. Yeah.
So it is still a high threshold that employers have to reach.
Yeah, yeah. I give an example. So I'm a consultant, and I go on about visiting lots of different places of work normally before COVID. And the majority of places I go, mostly small organizations, but they're just not accessible in any way, really. And neither do they have the resources or means to make their offices more, at least physically accessible. So you kind of, everyone's kind of, well, you haven't got enough money to do it. You're not really breaking the law. Are you breaking the law? You're not really. Even if you were breaking the law, I don't think I would bring anything, a case against you, because, you know, I want to work with you, not against you. Do you know what I mean? So it feels, the law seems a bit useless sometimes. Anyway, that was my input. I'll shut up now.
I mean, some of these cases might help clarify that. So if I go through the cases, so in Kane v Barclays Bank, Mr. Kane had worked for Barclays Bank for a number of years. Whilst he was employed by Barclays Bank, he had received a diagnosis of Crohn's disease, which obviously meant that he had to have access to a toilet, close access to a toilet, and immediate access to a toilet when required. Barclays did that adjustment. Sorry, somebody's calling me on Teams. I don't know if you can hear it. When he made that adjustment, he worked for Barclays Bank for a number of years, and they made that adjustment for him. He then moved branches, and the branch he moved to had the toilet wasn't near his desk. It was upstairs, and they had a practice of, when the money was collected or received at the bank, they locked the toilets and no staff were able to access those toilets. Obviously, that was no good for Mr. Kane. He asked for the reasonable adjustment to be made. They refused, and he was successful in bringing a claim for disability discrimination. Pemberton v Commissioners for Her Majesty's Revenue and Customs. Now, this is harassment. Now, the claimant suffered from rheumatoid arthritis, which caused her severe pain. Both parties accepted she had a disability, and the referral was made for reasonable adjustments for her, in particular through occupational health, as one of the things that had been identified was that when Miss Pemberton was in extreme pain, it affected her behaviour. She became, it's described as lively and unprofessional in the papers. But the manager quoted that in the occupational health report as well, and quoted that's how their behaviour was. And the tribunal found that the manager's description of the claimant's behaviour was unfavourable because his description of her behaviour could have negatively influenced the view of the person carrying out the referral, so of the view of the occupational health nurse. And it was also extremely hurtful for the claimant to read those comments in the occupational health referral. So the tribunal felt it wasn't proportionate for our manager to make the comments or to make the claimant's behaviour the sole subject to the referral. And as a result, it was found that there was harassment. The next one, this is an example of objective justification. So Mrs. Boyers was employed by the DWP and suffered from migraines and stress-induced panic attacks. She was signed off work with work-related stress, and she didn't return to work. She was off absent for over a year, and as a result, her employment was terminated as the employer made the assumption that she couldn't return to work in the foreseeable future. Mrs. Boyers made a claim for unfair dismissal and disability discrimination. The employer felt or defended the claim on the basis that Mrs. Boyers' dismissal had been a proportionate means of achieving a legitimate aim, so objectively justified it on the basis that they were protecting scarce public resources and reducing the impact on other employees from Mrs. Boyers' absence. Now, this when the Employment Tribunal held that Mrs. Boyers had been unfairly dismissed and suffered disability discrimination. However, the DWP appealed. And the Employment Appeal Tribunal were clear that when considering whether a discriminatory measure was objectively justified, the tribunal had to balance the needs of the employer, as represented by the legitimate aims, against the discriminatory effect of the measure of the employee. So it was a balancing act of protecting the scarce resources of the DWP against Mrs. Boyer's right not to be dismissed and not to be discriminated against. And this goes back to where I was saying, you know, they look at the resources of each employer when looking at any claim. The final one is the Chief Constable of Norfolk v. Coffey. So a police officer had suffered a degree of hearing loss, but that never caused her any issues in doing her job. And it was common ground that it wasn't a disability at all because it didn't have an adverse and substantial long-term effect. The police officer made an application to transfer to Norfolk, which was refused because the acting chief inspector of the new constabulary considered that the hearing loss would render her unable to do frontline duties. No medical evidence to support that, and no evidence that it ever had affected her ability to do frontline duties. Now, that was a direct discrimination claim that was upheld by the Employment Tribunal, because that police officer had been treated less favourably on a stereotypical assumption that even though it didn't have an adverse effect on her duties currently, it might do so in the future. So you can't look into the future as to what could be expected to happen. It is what is happening at that time. We all don't have crystal balls. So hopefully that is a bit clearer. Does anybody have any questions on any of that? It's hard when I can't see people standing in front of me.
I'll ask one, Claire. Is it? Am I unmuted? I can't remember. Are there any cases yet of long COVID coming through as disability?
There's not yet. There is, or certainly none that I'm aware of, there is a big backlog in the employment tribunals at the moment. I mean, you're looking at claims being listed the end of this year to the start of next year for any final hearing. There's a substantial backlog. So I think we're probably going to see those next year coming through. And I think that will also be along with any cases about anxiety, about returning to the workplace. So not just long-term COVID. I think there's going to be a lot about general anxiety, stress, depression from the current circumstances and going back into the workplace.
Great.
Claire,
Anybody else? Sorry.
yeah, sorry, Richard. Could I ask, you said earlier that the employer has to know about your disability. Could I ask, do you have to actually say, I am disabled to the employer, or can you kind of say, I've got this health condition that affects me day-to-day activities? What do they actually need to hear?
Yeah, you don't have to say that you are disabled. It doesn't, no, but they have to have knowledge of your condition. So if, for example, you're bringing a claim for reasonable adjustments because you say, I have to work from home, or I've had this time off because I suffer from depression a lot, and a reasonable adjustment would be for you to adjust your trigger points for the sickness. You can't bring a claim saying that if your sick notes all say you have been off because you've had food poisoning or flu or you've had an operation, because how could you then say to the employer, you should make that adjustment because you should have known that it was stress or depression.
I know you don't want to hear about personal claims and stuff like that, but I just want to give you this example. I wrote to my employer to ask for to work 3 days a week as opposed to 5. And I said, because I have arthritis in my spine and what have you. I didn't specify that it was due to a disability. I just said I have arthritis in my spine and I find it difficult in the winter, traveling, etc. And I get tired quite easily. Now, I ended up taking that claim to court, and they said because I hadn't actually used the words disability, even though the employer honoured the 3 days, they said that wasn't telling them that I had a disability necessarily. That's why I brought it up.
Right. I mean, there's a lot, normally employers, they would have medical evidence or occupational health reports or GP notes. So there's a lot of information that can be looked at rather than expressly stating, that you have to expressly state that you suffer from a disability. There is various levels of tests that you would need to go through.
conscious of time. Any final questions
I-
before Claire goes? Yeah, Chris.
Yeah, I've just got just back to that reasonable adjustments again about the. So say an organisation, you know, they're bound by the Equality Act, so they must make reasonable adjustments. But say they don't have enough
Oh,
work there.
I've lost you,
Any
sorry.
adjustments done, so you know it really works out that no disabled people get employed there. But nobody's done anything wrong, as it were. There's no been law breaking, but it's like the requirement to make a reasonable adjustment is just a bit. It just doesn't. There's no teeth to it. You know what I mean? What do you think?
Sorry, you were cutting in and out. I only got bits of that. I don't know if anybody else got bits.
It clicks out totally. Nope.
I think it comes down to, Chris, the issue of kind of what's reasonable, doesn't it? Is that the point that there are many ways in which an employer might argue that an adjustment is not reasonable?
I think perhaps if I can help.
Mhm.
What's reasonable, it's in the eyes of the beholder, so to speak. And that would be something that the tribunal would ultimately have to judge on. As Claire very rightly said, they will look at the size, the scope of the organisation, what the resources are. So it's difficult to say, well, this is reasonable, that's unreasonable. So there's no one size fits all answer for that, I don't believe.
Yeah, there's lots of issues. Thanks, Claire. And I know you have to get off to see to a client, and it's been a really good run through. There's lots of issues at play, and it's not straightforward. So it's good to have a refresher and a reminder of what the protections are. So thank you for that. It's much appreciated, your time and your input there. Yeah, and we're going to move into a quick 5-minute break, and then we'll come back and have the second half of the session. So, Kate, would you like to pause the recording while we go into a break? And
will do.
We're going to move from the kind of case law and legislative framework into, if you like, the more practical side of what happens and how do you take the challenge, and what are the things that are likely to help your case if you are in that position. So very pleased to welcome Stan Heslop, who is a qualified barrister, who's now a senior employment law advisor with the North East Law Centre. So I'll hand over to you, Stan. Yeah.
Hi, everyone. So my name is Stan Heslop. I work part-time at the North East Law Centre. And just as some background, we typically find about 80 to 85% of the clients that we help are coming to us with discrimination claims. And of those, we probably find that 80, 75, 80% of those people are looking at disability discrimination as a potential claim. And what we do at North East Law Centre is exclusively deal with claimants, and we can offer advice on the law, the process, etc., and occasionally represent. And I say occasionally because we look at each case on its merits, but also there are only two of us, who are there to provide representation and advice. So it's more a case of resources rather than anything else. So what I'm going to try and cover today in not so many slides is making the legal challenge. What do you actually do? What the process is, factors to consider, and then sources of help that might be available to potential claimants. And I'm sort of trying to slow this down to see if Richard come up.
Yeah, I'm getting there.
So what we do is we take claimants, we run a helpline, but also we can be contacted directly, and I or my colleague would get involved. I'm just going to drop myself out. So hopefully you can still hear me. In terms of making a legal challenge, if Claire was still here, I'm sure she'd agree. For any claimant, a legal challenge should be the last resort. First,
Should be sharing now.
well, let me see if it. Right. Can you just click to?
Yeah, I'll do.
Please, Richard.
Yeah.
I can't control it this time.
Yeah.
Yeah. Next one. Great. Thank you. So, firstly, try and resolve the situation with the employer. In any scenario, this is always the best option. It's much easier to say than do, particularly with disability issues. But as opposed to going to the tribunal, it's a better option. You should always, as a starting point, consider and make sure you fully follow any formal grievance process the employer may have. And the reason for this is that if it does go to tribunal, one of the first things that the judge will look at will be, did you actually raise a grievance? How did that go? Etc., etc. So always try and fully follow the process that the employer should have in place. Only then consider making a claim. And you have to start the process with a referral to ACAS. It's compulsory. It doesn't always end in a result, but you have to give them the time to try and resolve the situation with the employer as part of conciliation. At the end of that, it used to be 30 days. It's now been extended to 6 weeks because of the COVID. At the end of that, if or when it doesn't resolve the matter, you'll be giving a certificate number, which you then have to put into the claim form, which I'll cover later. Next chart, please. So what is that process? Some background to this is it is generally stated to be relatively straightforward making a claim. It's all online, but like anything, it is legalistic, and it is worth trying to get some help doing it, and that's irrespective of what sort of claimant you are. But it begins with ACAS reconciliation, a mandatory process, as I said earlier, providing 30 days, now 6 weeks. And in the event this fails, you'll be giving a certificate number, which you'll require for the claim form. You then move on to the claim form itself. It's called an ET1. You must complete that form. You can do it online, but it must be in time. And this is a critical point. The time is 3 months less 1 day, but is adjusted for the ACAS process. And what that means is if you believe you've been discriminated against, then you should report that within 3 months of the last event. Obviously, if you've been dismissed, that's very easy. You know when the day you were dismissed. But when there's an ongoing discrimination, including disability, then that can sometimes be a problem. And we often get clients who come to us too late. Late claims can be accepted, but you have to have very specific reasons why the claim would be late. In terms of ACAS, when we say stops the clock, if you move to ACAS 2 months after the event, and ACAS then take a month to try and resolve it, during that month, the clock is stopped and commences again once ACAS, if they haven't succeeded, stops. You then wait, and you wait for the employer to make their response. It's supposed to be within 30 days of receipt of the ET1 from the tribunal, but generally our experience is this takes longer. It can be 6 weeks, it can be 2 months. That can be because the employer or the respondent takes longer, or indeed the tribunal is just so backed up that it takes them longer to get it to you. We would typically chase the tribunal after 2 weeks of the date in which we thought the ET3 would be there. Invariably, if the employer is represented, then the ET3 would be accompanied by what's called a grounds of resistance, more commonly known as basically their defense. This is why you're mistaken, wrong, etc., etc. The process then continues with preliminary hearings. There can be one, which is generally, there can be 2 or 3 or 4. I have one client at the moment who's had 5, which is very rare. Generally, these are what those of us in the non-legal world would call admin meetings. They will decide who's going to do what, who's going to do when, and by when. So who's going to produce a bundle? When are you going to exchange witness statements? When are you going to disclose, etc., etc., etc. Sometimes there will be an application, generally by the other side, to do things like strike out or have an unless order or evidence admissibility. So the strikeout may be that the employer just decides that it's a vexatious claim that has no reasonable prospects of success, and they will apply to the tribunal to simply have the application or the claim struck out. Unless orders tend to come from the claimant, and this is where the employers haven't really done what they should have done by the date that the judge required. And when our patience runs out, we will go to the judge and say, please, can we have an unless order? It does what it says on the can. Unless the respondent does what is required, then they face a penalty or a preliminary judgment against them. Other hearings for preliminary hearings may be about evidence admissibility, if certain parts of evidence are allowed in or out. A classic might be a covert recording, although the law has got slightly easier on that. So those are the preliminary hearings. Generally, if it's a fairly straightforward case, 1, maybe 2. If it's an exceptionally complex case, it could be more. Next chart, please, Richard. Then eventually we move on to the final hearing. As Claire said, there are huge backlogs at the moment. Thousands, 10,000 or so or more cases backed up. The tribunals are trying to do hearings by Zoom, by telephone, varying degrees of success, but it is a long process. I would say to any client, if we're moving into a disability discrimination claim, it's going to take at least a year, plus or minus 2 or 3 months. So we move to the final hearing. The length depends on the complexity, the number of witnesses that are being produced, and typically discrimination hearings would be longer than a straightforward unfair dismissal and can be 5 or more days. They can also be further extended if there are vulnerable or disabled claimants or witnesses, or the case is particularly complex. We do find that the tribunal are quite good at providing time. I've had clients who, because of anxiety and stress, they can't face giving evidence or being cross-examined for more than certain bursts of time at a time. So we will always try and accommodate that with the judges and try and hopefully with the help of the respondent. Another possibility is ADR, alternative dispute resolution. Generally with employment law, with the type of claimants that we see and we deal with, this is judicial mediation. So one of these early preliminary hearings, the tribunal judge will always ask if both parties wish to engage in judicial mediation. And this is an opportunity to engage in a negotiated settlement where both parties try and find some ground in the middle, or some ground that they can agree to, where it's a non-litigious settlement. It's not a hearing of the case. It's not the judge deciding based on the evidence who's right, who's wrong, who may be mistaken, who might not be mistaken, whose case is the strongest. It is simply we are where we are. Let's see if we can settle this. We engage in many of these, and they tend to be a very good way of concluding issues, enabling particularly claimants to move on. And we would always suggest that they should be tried. They don't always succeed, but generally, if both parties go into it wanting or hoping to settle, then we can try and do that. And in fact, most disputes do settle, generally by a negotiated settlement accompanied by a non-disclosure agreement. We can help draft these, we can advise on them. Typically, although not exclusively, it will be executed through ACAS. And this would be through what's called a COT3. So if we settle, whether it's through judicial mediation or through NELC, us dealing with the respondents' representatives, we will eventually come to an agreement. That agreement will be thrashed out so that both parties are at least happy as they can be. And then we would pass that to ACAS, who would formally execute the document. And that means it's then legally binding. And perhaps that's for another day in terms of NDAs, because there's a lot of views. But a half decent drafted NDA that's not too draconian can work quite well. Next chart, please, Richard. So what should you as a claimant, what should we as a representative consider in going to tribunal? Well, it's not a trivial matter. It's not something like you see on TV when you watch these legal programs. It's slow. It will cause anxiety and it will cause stress, even if you're represented. The claimant will have work to do. When we represent clients, it involves a lot of client interaction and it involves a lot of work. We obviously do the heavy lifting, but there is input required. If you're a litigant in person, then it's doubly or triply going to cause anxiety and stress. If you're then on top of that suffer from a disability, whether that be physical or mental, then again, that just adds a layer of complexity and stress and anxiety. But it's not impossible. It shouldn't put anyone off just because it's difficult or complex or looks, no, it shouldn't put anyone off. You need to recognize it, but it can be managed. And quite often, including disability discrimination, we will advise litigants in person who then go on to manage the claim themselves. And at each step, we will try and help them in terms of this is what you need to do, that's what you need to do. After preliminary hearings, you will be given orders from the judge. These can be fairly legalistic, although if you're a litigant in person, they will be put in much easier, simple language. And on that, it's worth noting that litigants in person do receive a great deal of help and guidance from tribunal judges, much to the chagrin of respondents' legal representatives. But I would say that whether a barrister or a solicitor, you are required by your code of ethics and code of practices to help wherever possible. Particularly judges. I have a claimant at the moment who has had a number of preliminary hearings, and the judge's orders coming out of that have effectively told the claimant what her claim is and what she should be claiming going forward. Exceptionally helpful and basically doing a lot of the pointing in terms of the direction she should go. So again, it is difficult, it is complex, it's stressful, but don't let it put anyone off. Final hearings in particular can be lengthy and stressful. Tribunals will take this into account, particularly for disability issues and in certain parts of the process. You won't avoid cross-examination. Cross-examination won't be nice and it will be difficult, but there will be allowances made and time given so that it can be conducted in the best possible manner. And again, we would try wherever possible to prepare people for that if we're not representing them. Next one, please, Richard. So now let's see, well, you've told me all this, what's the sources of help and support? Claire very, very well covered the law, but as in terms of the clients we see, they generally don't want to lecture in law. They want to know, is there a problem? Can you help me? Can we fix it? And ultimately, what sort of compensation will I get? But generally, the majority of clients just want to know, is there a problem? Can you help me? How can we try and resolve this? There is no legal aid for employment law. Solicitors can provide help and advice, but this depends on the firm and the seniority of the people involved. They will charge fees. That's the downside. Many of the claimants we help are in relatively low pay positions, and they can't afford to go out and hire a large legal firm who charges anything up to £250 an hour or more. But sometimes, particularly high street firms, may offer a free 30-minute consult. And in some instances, although I say this is rare, they may agree to represent on a conditional fee basis. Now, I don't want to make too many comments about these things, but at the end of the day, they are only going to take it on a conditional fee basis if they really believe you've got a very strong claim. They're not going to take it on if it's sort of a 50-50 or less. Some barristers' chambers may offer direct access, whereby a barrister can be instructed directly by the client. This was a change in practice several years ago. Typically, if you instruct a barrister, it has to come from a solicitor first, and you do end up paying 2 sets of fees, which is obviously not that great. But there are occasions now, depending on the case, depending on the chambers, where you can instruct directly. It tends to be a professional instruction rather than directly from the public, and it's not that widely available. The downside is, even if it works, is the cost may be about the same, but you do end up doing an awful lot of work. Barristers don't do a lot of stuff in terms of research of the facts, etc., of obtaining certain parts of evidence. That will end up being down to the client. Next chart, please. So what people are particularly interested in is, where can I go to get some advice that won't cost me an arm and a leg? So where are these free sources of help? There are quite a few. First one, we always refer people to this, is the union. If you're a member of a union, you pay your fees and you have a right to legal advice with the larger unions, and sometimes representation. The downside is these are relatively busy departments, lawyers, and they will tend to only represent the strongest of cases. Citizens Advice Bureau. A lot of our claimants are referred from CAB. They will offer initial advice, but it varies across offices and regions, and it varies depending on the experience of the advisor. And so we get some very good referrals, and we also get referrals where people have been told that they've got a very good claim when actually they haven't. So, but it's a good starting point. And as I say, we have arrangements with some CABs where they will refer them to North East Law Centre, and we will take it from there. ACAS, they will give some advice, but typically they're there to try and resolve the issues rather than give a view on a claim, but they can sometimes help. Some of the university run employment law clinics. These are provided by students under supervision. They are always only advice only and have very limited availability. I think Northumbria used to run one. Certainly Sunderland did. I was mentoring and supervising some students on that. But that was 3 clients who could only do 1 day, etc. So that they're very limited, but it's a possible source. Then we have law centres like NELC. I will shamelessly advertise us. We can provide detailed advice. Some, like Northeast, will provide a representation if we can. And another one here, which has actually just popped in my head that I remember, the Bar Council also have something called the Free Representation Unit, whereby, again, law students doing bar exams who are in their final year, who are very well supervised. I used to work for Free Representation Unit in London as a volunteer. and they can also. So it's always worth looking at Bar Council websites to see if there's a one. There is a very big one in London, but I'm not sure about the regions. I think that's the end, Richard. Right, we can drop that and go back to full screen if you like. Okay. I hope that was helpful. Does anyone have any questions I could try and help with? I think everyone's on mute, so that might be difficult.
I'd be interested to know, Stan, whether you think, is your perception, is it getting harder to take a claim or not over the last sort of 5 to 10 years?
If I'm honest, no. I think that the law has changed. And I think if I go back to my original statement, the employers generally now have got over their problems with unfair dismissal. They seem to know what they're doing. And that's why I think most of the claimants or most of the clients coming to us are looking at discrimination, and in particular disability. And I think in those instances, the respondents fall into 2 categories. The ones who really don't know the law and don't know what their obligations are and do things they shouldn't do. And there are those who either know the law and don't care, or just haven't got a clue and don't do that. So in those instances, I think it's not more difficult. I think what puts a lot of discrimination clients, and particularly disability clients, off is they themselves don't understand the law, don't understand, probably the wrong word, are not knowledgeable of what the law is. And they then, if they are, as I said, get anxious and stressful about what looks like a hugely complicated process, and certainly a long process. So I wouldn't say it's more difficult. I think it's there to be used, and it shouldn't stress people out, which is easy for me to say, rather than someone who's suffering. But try and get advice. I mean, we will at North East Law Centre very quickly tell you if we don't think you've got a claim. In fact, the hardest part of my job is telling people, well, actually, you may have been treated very, very badly, but it hasn't crossed the line into unlawfulness, and that's what we have to look at. So no, I wouldn't say it's become more difficult. It's more about knowledge.
Yeah. Okay. Any other final questions before we finish? No, just give people a chance. No, I think we're done. Thank you, Stan. That was really, really helpful. Really a good insight into just what to be aware of. Considering, hopefully we don't get into these situations, but I think sometimes we have to be prepared. Sometimes it feels like it's the only way to enforce your rights. It is to take it to a legal challenge. So
I think the key thing is get advice. Now, I shamelessly push NELC. That's what we're here for. If you can't get through to the helpline, which is every Thursday, drop us an email or call reception. They'll take details. We will get to you. And that's what we're there for. And as I said, quite often we can just point people in the right direction. Even if it's just simple as, well, have you raised a formal grievance? No, this is what you need to do. So it's a case of get some advice. It's much easier to get the advice and then for example, know you maybe haven't got a claim, then sit and worry about it and then think, what if? Because we have a lot of clients who think about, oh, well, I don't know. And they wait until 4 months down the road, and they may well have a good claim, but we have to say, well, you're too late.
Yeah.
I also have a lot of clients who commence litigation as litigants in person, and they ring us the day before a hearing and say, oh my God, I have to go in front of a judge tomorrow. I'm screaming petrified. What the hell do I do? And that doesn't give us a lot of time to prepare. So if you have decided to commence a claim and you suddenly realize, oh my God, I'm at my depth here, I haven't got a clue, what the hell does this mean? Again, come to us as soon as possible, because it's never as bad as it seems. We're in front of judges every week. And sometimes what looks like a really scary thing that the judge has asked you to do isn't that scary. And it's sometimes, to be honest, the legal language that's used that puts people off. Like, you have to attend a preliminary hearing. Most of these are what I would call admin hearings. They're nothing to be scared of. So yeah, that's my shameless plug.
Thanks very much. We'll wrap it up here. So thanks again to